Hi, it's Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer. Today I'd like to talk about, what would you want to do, or how would you go about doing it, or here are a couple tips to go about doing it if you want to leave your ex-spouse something after you pass away. But before I get started, if you ever have any questions about a Northwest Indiana estate planning or probate matter, you can always reach out to me at indianaestatemeeting.com and we can get together and answer your questions either in person, by phone, or by video conference. So here's the story. Look, you didn't get along with your ex-spouse. There was a problem. You still love them. They are the parent of your children, and you still want to go ahead and leave them something after you pass away. But there are some concerns about that, and there is some operation of law that you need to understand before you go ahead and do it, thinking that they would be able to get some of your proceeds, but yet they aren't because of the way the law reads. And so this is the first issue. First issue is, say that you still have your will that you had when you were married to your ex-spouse. Well, at the time that you were divorced, under operation of law, your ex-spouse is deemed to have predeceased you. So at the time that you signed that divorce decree, they will no longer take under your will. So if you want to leave them something in a will, you are going to have to prepare a new will after the time of your divorce to leave something to your ex. The other way that you can do it is you can do it by beneficiary designation. You might want to sign a beneficiary designation leaving a percentage of either life insurance to your ex-spouse or all of your life insurance to your ex-spouse, especially if you have young kids and if something should have happen to you, you want the money to be used for your kids. Or you could leave it in trust for the kids and have your ex-spouse be the trustee for your kids if you trust, no pun intended, the ex-spouse. Or you can go ahead and leave part of your bank account or part of a retirement fund or anything else that you can distribute by beneficiary designation. You can say, I want my ex-spouse to get 25%, 30%, 40%, 50%, 100%, whatever it is. And if you do it by beneficiary designation, then you don't have to worry about the operation of law that has to do with wills, and you don't have to worry about updating your will. But if you listen to some of my other videos, the time when you get divorced is a perfect time. It's enough of a change in your lifestyle and circumstance in your life to have your estate plan and revisit your estate plan and possibly update your estate plan. So there you have it. If you want to leave something to your ex-spouse, there's pretty much two ways that you can do it, or three ways. First is by beneficiary designation. Second is by putting them in a will that is dated or that you entered after the date of your divorce. And third is leaving them as a beneficiary in a trust that you establish after the date of your divorce, or even actually before your divorce, because it doesn't work the same way as a will. So if you left your ex-spouse as a trustee or a successor trustee to you, or a beneficiary in your trust, that's still going to hold true, because most trusts do not have to go to court. They're just a contractual relationship. If you have any questions about a Northwest Indiana estate planning or probate matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.